Hi there, my name is Jennifer Guimond-Quigley. I'm an attorney and I'm licensed in Illinois. I have been retained to assist Raymond Riat and Glenn Dunn with respect to the assistance of collecting the appropriate documentation and paperwork so that all of the plaintiffs in the Hillside Landfill Odor settlement can obtain their settlement funds. And specifically with respect to any plaintiffs that have passed away during the pendency of the litigation, my job is to assist in obtaining the paperwork related to those deceased plaintiffs. So you are viewing this video because you received a packet in the mail requesting that you submit what's called a small estate affidavit. And so this tutorial is going to go through the small estate affidavit. And what I hope to do is to clarify and explain what information is needed with respect to each of the questions in the small estate affidavit, so that you can make sure that when you submit it, it's complete and it's accurate, because the only way that the small estate affidavit can be used in order to administer the asset is if it's full and complete. So the first thing is, and I'm not going to go into detail about who should be filling out the affidavit. The proper affiant who should be filling it out, that detail is set forth in the letter that you received. So I won't go into detail on that for the purposes of this tutorial. However, please note that with respect to the small estate affidavit, you're going to have to submit a death certificate of the decedent with that small estate affidavit. It can be a copy or it can be certified. Either one will work for our purposes. Secondarily, if the decedent who's named in the small estate affidavit had a last will and testament, then we need also to receive, in addition to the death certificate, a certified copy of the last will and testament. The way that you receive a certified copy of the last will and testament is to obtain that from the courthouse where the will was filed after the death of the decedent. If the will was never filed, it needs to be, and it would be filed in the courthouse in the county in which the decedent passed away. And then you can obtain the certified copy from the court clerk. I'm going to go ahead and pull up the small estate affidavit and we can go through it line by line and try to clarify some of the commonly asked questions that we've seen. Okay, this is what you're going to see in your packet, the small estate affidavit. In the first field, it asks for the affiant's name. This is the person who's completing the form. So if you're the family member of the person who passed away, and I'll just refer to that person as the decedent for purposes of our tutorial, then your name as the affiant, the person filling out the form, will go in this space here. The postal address is just going to be where you receive your mail. So if you happen to receive your mail at a post office box, and that's different than your residential address, then you'd put the post office box here in the first line and your residential address in the second line. If you just get your mail where you live, then you will put your residential address in both lines of number one. If you live out of state, you're going to need to additionally name an agent for service of process in Illinois, and that person or law firm would go here under subsection C. However, if you leave this blank, then the agent for service of process would be the clerk of the circuit court, and then you're going to put the county in which the decedent died and the circuit of the court in which the decedent died. So for example, and you can look this up online, Cook County Circuit Court would be, so you would put Cook here in this field, right above where it says county, and we're the first judicial circuit. And that can be obtained from the courthouse homepage, or you can contact the court clerk and ask them, what judicial circuit are you? So where the decedent died, that is what's going to be the county here, and then the judicial circuit of the courthouse located in that county is what's going to go here. Number 2, you're going to put the name of the person who died. So that's what the decedent's name is. Number 3, you're going to put the date of death, and just make sure you confirm it with a death certificate. They need to match. So the date of death of the decedent will go here in line 3. And then it does state that you have attached a copy of the death certificate. So that's a reminder to make sure you get that attached. You're going to list the decedent's place of residence right before his or her death in field 4. Number 5 is a statement. So as long as this is true and correct, you can keep on filling out this form. If this statement number 5 is not true or correct, then you need to stop filling out the form and this form won't be applicable. Number 6, this is where all assets of the estate are going to be listed. Please note that if there's real estate in the estate of the decedent that the decedent owned individually or as a tenant in common with someone else, or if there are assets in aggregate over $100,000 in the decedent's estate, the small estate affidavit is not appropriate. The decedent will, the family heir or the affiant, whoever's filling this out, will need to proceed with a different route for the administration of the settlement funds, which would be to open up a probate estate to receive those funds. So what we've done for purposes of the small estate affidavit to assist the plaintiffs in this case is we've initially listed one asset here, and that's the settlement proceeds from the, this is the official court name, Gwendolyn Amber versus Allied Waste et al. This is the case number, and it is also designates the Cook County Court in which the case is pending as an asset. And then what we're putting on each of the respective small estate affidavits is the gross value of that distribution. We're putting that here in this field for you. So that's going to be filled out for you already. Only will you need to fill out these blanks here if there's any additional assets that the decedent owned at his or her death that still need to be administered, such as bank accounts, automobiles, personal property, anything else that's in the decedent's estate would be listed out here. And if you need additional room, you can certainly fill out an additional page. But largely we're saying that this asset is the sole asset of the estate. And so in that event, you would just leave this line and the amount that we populate here as is and move on to the next question. Number 7, as you can see from the instructions, you need to choose either A or B in section 7 and cross out the section that doesn't apply. If the decedent's funeral expenses and other debts have been paid in full, then you will keep A, and you can even circle it to make sure that everybody knows that that's the one that applies. And you'll strike out B and all of the following provisions of 7B. So all the way through here will be crossed out. If 7A applies and you're keeping 7A, then 7B needs to be crossed out in its entirety. If there are unpaid debts from the decedent's estate in any of the categories listed here, then you need to cross out A entirely and fill in the appropriate fields in 7B with what debts are still pending. And it goes into detail for each particular type of debt, and you would list out each of those items. Now, class 2 surviving spouses award or a child's award, we'll get into what exactly that means a little further into the document. But if you are a surviving spouse, you are entitled to a spousal award. And if you have minor or adult dependent children residing with you, there's an additional award on top of it. So we'll come back to this, but if you fall into that category of what I just stated, you're a minor child, a surviving spouse, or an adult dependent child, there may be an award that will go in class 2. So we'll look at that in a little bit. Keep going, and again, you're just going to fill in any of these fields with the amount of the debt that you are aware of with respect to the decedent. Okay, now 7.5 is a statement of fact. And if you cannot comply with this statement, or if it's not true, then you shouldn't proceed with a small estate affidavit, and you should proceed with opening a probate estate. it basically says that you understand that if to the extent there are any debts or claims up in in the earlier part of 7B, those get paid before anything else gets paid from these settlement funds and from the remaining assets of the estate of the decedent. So that's just a statement of fact, and so you don't have to do anything there. Number 8 is another statement of fact. There are no known unpaid claimants except as stated in paragraph 7. If that's true, you can continue filling out the form. If that's not true, then a small estate affidavit won't be appropriate. You will need to open a probate estate. A contested claim against the decedent means that someone's making a claim for a debt that was owed by the decedent, and there's a dispute as to whether it should be a legally enforceable debt or not. In that event, a probate estate should be opened. Number 9. Number 9 is only completed if at the time of the decedent's death there was a surviving spouse, minor children, and or adult dependent children. And here in 9, it defines an adult dependent child as one who is unable to maintain himself and is likely to become a public charge. So if any of these 3 circumstances exist, we need the name of the person, the relationship to the decedent, the place of residence, and if it's a minor child, the age. Many people may not be completing section 9A if there's no surviving spouse, no minor children, and no adult dependent children. So 9A would just be skipped in that event and you wouldn't fill it out. Now, if you're going to be claiming a spousal award, this 9B tells you how to calculate it. So it's $20,000 to the surviving spouse off the top of the proceeds, plus $10,000 multiplied by the number of minor children and adult dependent children. So if you have a surviving spouse and 2 minor children, the total spousal award would be $40,000 because it's $20,000 for the spouse's award plus $10,000 multiplied by 2, and that's $20,000. Add the 2 together, you get the $40,000. If you have a surviving spouse and an adult dependent child, just one, then it would be $20,000 plus $10,000, or a total of $30,000 for the surviving spousal award. If there is no surviving spouse, then there's an award allowable for minor children and adult dependent children, and that amount is $20,000 plus $10,000 multiplied by the number of minor children and adult dependent children, to be divided amongst those individuals in equal shares. So if you filled anything out in 9A, then you would want to calculate the applicable award that's due in B or C. Okay. Now, number 10, this particular section needs to be completed either A or B. So you cannot leave both sections blank. So A will be completed if the decedent did not leave a will. So if there's no last will and testament, then what's going to happen is the estate's going to pass via intestacy, which means by virtue of the descent and distribution laws of Illinois. This will be filled out in the event there was no will. If there was a will, you must fill out section B. And section B wants you to attach a certified copy of the will to the small estate affidavit, so make sure you submit that. And then also, you would need to read through the will and see what the decedent wanted in terms of the distribution of the estate. And then you would put the legatee's name, so the person who's supposed to get the money from the estate, or persons, if there's several people named, the address, and if it's a minor, the age, and what percentage or amount of the estate has been allocated to that particular person under the will. So you have to read through the will's terms and make sure that they're reflected on the form in these fields. Now, with respect to 9A, I'm sorry, strike that. With respect to 10A, if you're filling that out, then you need to make sure you review the tip sheet. We've also included a tip sheet in your packet. it tells you what the laws of descent and distribution are in Illinois. Essentially, I'll go through a couple of examples of the most common, but if there's a surviving spouse and also a child of the decedent, then half of the estate goes to the surviving spouse and half goes to the child. If there are several children, then half goes to the spouse and the other half is divided between the children that survive. If there's no surviving spouse, but a descendant of the decedent, then the entire estate will go to the decedent's descendants. Per stirpes. Per stirpes means that if the decedent had a child who predeceased him or her, and they had their own children, so grandchildren, the grandchildren take the child's share. So if you have a person who had no spouse but 3 kids at their death, and one of those children died before the decedent and had 2 children of their own, the 2 grandchildren would take 1 share and the other 2 children would take the other 2 shares for a total of 3 shares. So read the tip sheet. It does go through the descent and distribution rules and who gets what. If you're not sure, certainly you can contact the office and we can tell you what the percentages go to each family member if you let us know who survived the decedent. We can assist you. But I've given you the most common scenarios that we've seen. And if there's a surviving spouse and no children, then it would be 100% to the surviving spouse. So you'll, again, cross out, do an X through the section A or B that doesn't apply. Fill in A or B and then cross out the other section so it's clear. And number 10, this sub C is just a statement of fact. If this statement of fact is true, continue to fill out the small estate affidavit. If it's false, then you should be opening a probate estate and the small estate affidavit won't be appropriate. 10.3 says my relationship to the decedent or the decedent's estate is as follows. So you are the affiant, you're the person filling out the form. What is your relationship to the decedent? Are you the daughter, the son, the spouse, the mother, the father, the sibling, brother, sister? Put that relationship there. Or if you're not related to the decedent in any way, put your relationship to the estate. What is your relationship to the estate? Are you a creditor who's seeking to obtain money to pay off a creditor's debt? That's the information that would go there. The vast majority of you will be putting in the relationship because most of you are family members. 10.5 is another statement of fact, and it's a statement that says that you understand that the distribution of the estate must first be made to satisfy claims against the decedent's estate. So up in paragraph 7, where you listed out any debts and claims, those get paid first and foremost. And you're saying that you're agreeing to sign this affidavit and indemnify and hold harmless all creditors of the estate and the decedent's heirs and legatees or any other persons, corporations, or financial institutions that rely upon the affidavit. And you're taking personal liability in case the affidavit is not filled out correctly or the estate funds are not distributed appropriately. So if you're not comfortable signing this with that in mind, then again, you may not want to use a small estate affidavit, and you may want to open a probate estate to have the court orders to protect you as the person who's administering the estate. A lot of the estates are fairly simple, and if there really was no debt and this is the only asset of the estate, then there shouldn't be no problems using a small estate affidavit to administer this particular asset. But there are certain circumstances which are listed in the affidavit that if they're present, then this should not be used and you should open a probate estate instead. After payment, number 11 talks about once the payment of the debts and expenses as listed in paragraph 7 are made, or if there are none, then that number is 0. Any remaining property described in paragraph 6 should be distributed as follows. And then it asks you to actually list it out. So let's go back up to paragraph 6 so you can see and remember what that paragraph was. So paragraph 6 was the assets of the estate, right? So we've got paragraph 6 here, the assets. So this is all the assets in this paragraph and the value. You're going to restate them below in paragraph 11 and say who they get distributed to. So again, you're going to have a value here in this field next to the settlement proceeds. You'll have that amount provided for you. So let's just say for purposes of this tutorial that amount is $5,000. So let's go down to 11. So you're going to state in paragraph 11 the name of the person or people. If there's more than one person, you're going to list them all out here of who's getting that $5,000. Then you're going to say the specific sum or property to be distributed is a certain amount or percentage of the settlement proceeds, and you'll want to just really restate that specifically, just as I have it here. So you'll say settlement proceeds from Gwendolyn Amber v. Allied Waste et al. Circuit Court of Cook County. So you'll just restate that exactly. And then you'll say what amount or percentage will be distributed to that person that you have listed here. Sometimes it's just easier to do the percentage. So if there's a decedent who died with 4 children, adult children, then, and there's no deaths, it will be child 1, 2, 3, and 4. You'll list out the settlement proceeds, identify the settlement proceeds identically to what I have above, and 25% for each line. Probably the easiest way to do it. And then most importantly, you'll be signing your name where it says signature of a client, and you do need to have it notarized. So you'll have to take it to a notary public. The best place to start would be wherever you bank. Typically they have notaries on staff and on site. You may want to call in advance to see if they have someone there before you go in. If that's not available, then currency exchanges will typically do a notarization for you for a minimal fee. You can also try them. And then the rest of this small state affidavit is just some additional explanatory language from the statute. You would want to read through that. And so that is the small state affidavit from start to finish. And in the cover sheet to the small state affidavit, you'll note that there's a phone number and a name for Raymond Riat's law clerk, Isa, who you'll want to contact when you're done filling out the small state affidavit, just so she can run through it with you and confirm that everything is correct, because it's going to be a lot quicker and easier for you to obtain those settlement proceeds if the small state affidavit is filled out completely and submitted with the appropriate paperwork, which would be the death certificate and, if applicable, the certified last will and testament. Okay, that's all. Thank you so much for listening.